Hello and welcome to the big picture. The Union Cabinet has decided not to challenge the Bombay High Court judgment, which had absolved Vodafone of any tax liability worth rupees 3,200 crores demanded by the Income Tax Department. This decision of the Union Cabinet, taken in tune with the advice given by the Attorney General of India earlier, goes against the decision of the UPA government, which had brought in an amendment to the Act to facilitate retrospective taxation. This decision of the UPA government had been seen as having affected foreign investments in India. The NDA government, though had not made any changes to the law, was however not in favor of retrospective taxation and had assured to end tax terrorism, as one of its leaders had termed. So with this decision of the government, will it trigger investments from abroad? Will it also end the uncertainty and lead to a stable tax regime? We will discuss all this today with Prashant Bhushan, lawyer in the Supreme Court, S.K. Jindal, Chairman Investment and Investors Protection Committee at the ASSOCHAM, and K. Badarinath, Editor Policy at the Financial Chronicle. Welcome to all of you. Mr. Jindal, how do you look at this decision of the Union Cabinet? You think that this was the right decision?
Very positive, very welcome decision. Mistakes, whenever corrected, they are good. It was a very big mistake. In my 40 years of business career, I could not have imagined these kind of retrospective tax amendments. They don't work. When you are dealing with a nation of 125 crore people or any nation even smaller, you don't make retrospective adversarial amendments and laws. You make everything perspective. Nobody is supposed to know what is going to happen tomorrow, and they cannot take into account that. They have done with certain imagination, certain systems, certain rules in mind. And if they change overnight, small companies might have failed by now. This is Vodafone, they could sustain it, although they were having big pain for that. But this kind of thing should not have happened, and it has costed the country too much money, too much penalty to themselves, because lot of investment which wanted to come did not come. And now that air has been cleared, now that things have been corrected, there is a change of government and people know that this was a mistake by them, and now it's a new government, so they can rely upon. Seeing all other things also, what is happening in India, so they now the things look very good and stable and reliable and predictable. Tax laws, they have to be predictable, they have to be understood by 125 crore people and people from overseas also. So they have to be very, very stable. You cannot run the country with unstable tax laws.
Okay. Prashant, is that the way you look at it? I remember, in the past you have had some problems with this. You had said that in this whole case you were saying that the government, the retrospective amendments which were brought in, do you think it was the right thing to do, and what do you think of the latest decision of the cabinet?
You see, the latest decision of the cabinet doesn't have anything to do with the previous issue of taxation of the sale of the Indian telecom company. That is when Hutch sold its Indian telecom company to Vodafone. At that time they had a capital gain of some 50,000 crores, more than 50,000 crores. The question was whether that capital gain, which had clearly accrued in India on the sale of Indian assets, that is the Indian telecom company, whether that is liable to be taxed in India or not.
Right.
At that time, Hutch and Vodafone put up the case that no, we have the transaction has taken place in Cayman Island, because there is one holding company which has one share which is in Cayman Island, and the transfer of that one share has resulted in the transfer of the Indian telecom company, and therefore that capital gain has not accrued in India at all. On that, the government only issued a clarificatory amendment saying that, look, it doesn't matter whether the share has been transferred abroad. If the underlying asset which it relates to is really in India and that's what has been really transferred, then it will be deemed to be a transfer of a capital asset
Absolutely.
in India and therefore liable to be taxed in India.
Right.
That was the known position all through. The government only clarified that and said that this clarification is issued with retrospective effect. because that was the law. Unfortunately, the courts had gone wrong. The Supreme Court had gone wrong. The High Court had given a correct judgment, but the Supreme Court had gone wrong against the 7-judge judgment in McDowell's case, which had said that the courts must make every effort to defeat any attempt to evade taxes or to avoid payment of taxes.
Right.
Which is what should have been done, and which is what the government did by that clarificatory amendment.
And also,
now, the present thing has nothing to do with that. This is a different transaction altogether. Here the issue is whether issuance of shares by one Indian company to its holding company which is abroad at a value which is less than the market price of those shares, whether this transaction, whether any capital gain or any income can be said to have arisen to the Indian company on account of this transaction, whether it is real income or deemed income under the Income Tax Act, and if so, whether it needs to be taxed. On this, the Bombay High Court has taken the view that no, this is not really income, because this is only transferring or rather allotment of shares in that company itself to a parent company. Therefore, any money which comes as a result of this, whether deemed or otherwise, is not really income of this company. Now, that's a possible view, it's a plausible view which one can take, and therefore, if one is clear, if it is absolutely clear that that's the only plausible view, then yes, the government can decide not to file an appeal against that. But to decide not to file an appeal on the basis that this is going to help foreign investment, etc., that's not a correct view at all, because you cannot take a decision. Government cannot allow loss of tax revenue in this country merely because it is going to help foreign investment. It is the same view which has allowed this fraudulent Mauritius double taxation agreement to continue in this country for so long, which effectively allows companies, post-box companies coming in through Mauritius to avoid paying any taxes in India, which are legitimately payable by them.
Okay.
So
Prashant,
therefore, this kind of thing of allowing a tax holiday to foreign companies on the ground that it will attract more foreign investment in India through this subterfuge, etc., this is not permissible to my mind.
Okay.
This is not in public interest at all.
Okay.
And this cannot be the reason for taking this decision. But
Okay.
otherwise, if they feel that this is the only view possible, then fine.
Okay, I'll come back to you. We have Mr. Ajay Dua, former Secretary, Ministry of Industries and Commerce, on the phone line with us. Mr. Dua, how would you look at this decision of the government? Prashant says that if it is thought that this is the only way, this is the only way it can be done, so if the government's decision is okay. But if it is done with a view that it will encourage foreign investments, then there is a problem with it.
I agree with him on his this point of view, but at the same time, any taxation regime has to be predictable. We cannot be taking one point of view in a particular case, take one point of view, a particular view, then change it. Hitherto, the issue of transfer price, this is a part of transfer pricing issue. In transfer pricing, we have been taking different views at different points of time. It just goes from the fact that, there was the total transfer pricing income used to be about 10,000 crores, which for last year, it was hiked up to 70,000 crores, that we'll extract that, and the whole taxation regime really became extremely aggressive and went about interpreting laws, the rules, in the manner which they liked. And this was one such case where the entire revenue is capital in nature. That was sought to be looked at as if it's a receipt of a taxable income receipt. This is what the High Court of Mumbai has said, that we will not, we do not accept this as a taxable item. The transaction was capital in nature, and that this was capital in nature,
Okay.
and hence it is not taxable.
Okay,
So
sir.
I think
I'll come back. I'll come back to you, Badarinath. How do you? I mean, this was very clear right from the beginning. The NDA government came into picture. This was happening, but there was something that which was expected when the budget was presented. The finance minister was clear that he's not going to take the burden on this.
Yeah, but in this case, there are two separate issues. One is the issue of retrospective taxation, which is completely a different case. In the case of Vodafone and the Income Tax Department relating to the Hutch assets, as Mr. Dua was saying. In the case of the cabinet decision that has been taken yesterday relates to the transfer pricing
issue.
Transfer pricing, where the question was whether it is.
But it emanates from the same deal which was done between Hutch and
that's precisely what I'm trying to tell you. It doesn't emanate from that.
Okay.
It doesn't emanate from that. Some shares of the Indian subsidiary were sold to the parent company, and at what price will it constitute an income, and that is taxable. Even the issue of whether the the tax liability was 3,200 crores or not is not right, in the sense that the taxable income was supposed to be 3,200 crores, which the Income Tax Department raised, and perhaps that is what as Mr. Dua was saying, the High Court has struck it down, and so Income Tax Department does not have a case. That is what
as far as the demand which they have made is concerned. Okay, Mr. Dua, how will it affect the other cases? They're talking of other cases also having.
I believe there are half a dozen such cases which are before the which are affected at Shell, Nokia, Leeton, and a couple of other cases. The issue, to my mind, is not how many cases get affected. It's a question of a principle.
Okay.
Whether a particular receipt can be called income, which is taxable, or is it capital in nature, then you look at it whether it is liable for capital gains or not, for how long you've held the shares, long term, short term, etc. In this particular case, issue of shares to your own company, this is not, it was not a holding company as was being said earlier, it was to another Vodafone Mauritius.
Right.
Vodafone Mauritius has been given 29 lakh shares, 2.98 lakh shares at a value of 8,531 each, which the tax person said that the taxman said that this is undervalued. To that, and then they went about calculating and saying 3,200 crores, etc., plus certain penalties, etc., are due to you. It is not the calculation which the High Court has gone into. The High Court.
How did okay? You're saying that it's a case of it's a case of principle. It's a question of principle, and now that Mr. Jindal, now that this has been cleared, now that the government has decided that it will not challenge the Bombay High Court order, so you expect this kind a stable tax regime to be established with this?
Yes, this sends a good message, and anything, I would consider this as a practical view they have taken. It sends a good message, and good message for further investment into the country, which also we cannot ignore. And as long as whatever we are deciding, it is in interest of the nation, we can decide it. There is, you see this ad in the TV which says, "Agar daag अच्छे के लिए लगे तो दाग अच्छे हैं."
So you're trying to justify what Prashant Bhushan said about the existing arrangement, the Mauritius route and all. This is another such instance. Is that the dag which you're talking about?
No. I am talking about this particular matter. This has lot of litigation had taken place, and it was sending wrong messages all over the world, and which was not in the interest of the nation as such. Now that it has been corrected, I feel that right message will go, right sentiments people will have about India, and they will be able to deal with the Indian tax laws with some more confidence and more predictability, which is very necessary.
Yes, Mr. Dua.
I think yesterday, while taking a call not to appeal against the Mumbai High Court decision and to decide similarly placed cases likewise, which is about half a dozen cases, another decision which in this respect got taken was as long as ITAT, that's the Income Tax Tribunal, and the dispute resolution mechanism, which is set up by the government, both these are government bodies, that if these bodies have taken a view, we will respect them. If somebody goes to the court after their decisions, the government has not said we will not appeal against them, saying the bodies which we have created or organizations which we have created to settle disputes, if
we will abide by it.
We will abide by it, which is how an executive should function.
Yes, Badri, you have a point.
See, here the issue was valuation. At what value the Indian subsidiary shares were sold to the parent company was the principle of arm's length distance being adhered to or not. And today the Bombay High Court says that no, it has been adhered to and you have no case to raise tax liability or tax demand on the company, and henceforth it is stuck down. One. Second is Mr. Dua was talking about more such cases. It's not only foreign companies, there are domestic companies.
Domestic companies.
Where, like Bharti Airtel, there is Havels, there is Patel Engineering. So there were 8 other Indian cases where this, the transfer pricing issues were being dealt with. I mean, it's not that the foreign companies have been, unduly favored or any such thing. It also, the principle established by the Bombay High Court and which has been endorsed and supported by the cabinet only clears up a lot of confusion that was there. The Vodafone case along with the Hutch assets is completely different and that relates to retrospective taxation.
Okay, Prashant, so would you agree that this clarification made by this decision taken by the Union Cabinet will lead to a stable tax regime in this country, and this kind of confusion which prevails, as my other guests are saying, will be cleared and it will lead to a better business environment in this country?
No, I don't think anybody is clear about what has been done. You see, this is neither an issue of retrospective taxation nor even an issue of transfer pricing. You see, if for example a company sells some shares that it owns as an asset to its parent company at an undervalued price, then certainly the issue of transfer pricing would be there, and then it would be perfectly correct for the tax authorities to say that, look, this is an undervalued price, the arm's length price would be this much, and therefore you have to pay the tax on the arm's length price. That will be deemed to be your capital gain on which you have to pay the tax. However, in this case, I think the issue was whether shares issued by a company of itself, new shares of the same company issued to a parent company, whether the consideration received from the parent company for this, whether this amounts to a capital gain or any income at all. And therefore, the Bombay High Court said that this does not amount to income at all. It was not an issue of transfer pricing, and that this undervaluation has been held to be a correct arm's length price. That's not the finding of the Bombay High Court at all. If this is going to be treated as a precedent for that all issues of transfer pricing will henceforth be closed, and whatever price the company sells any shares to its parent company would be deemed to be correct, then I say that this would be a totally wrong and pernicious principle, and merely because it is avoiding some foreign company or any company to pay some tax, etc., we cannot, as taxpayers of this country, as citizens of this country, we cannot applaud a decision of that kind of the government.
Prashant?
The government cannot take any decision not to appeal on the basis that this is going to help foreign companies not to pay tax, and it will
Prashant,
increase confidence of foreign investors in India. That can't be the basis.
No, Prashant, quickly, so do you think that, in your opinion, in your personal opinion, do you think that the decision taken by the government is not correct? So do you expect Did you expect the government to challenge this in the Supreme Court, or what are you trying to say?
I'm saying that the decision whether to challenge a High Court judgment or not has to be taken by the government on merits. If the government feels that this judgment is absolutely correct, and the other point of view which the tax authorities were espousing is not really an arguable proposition which needs to be taken up in appeal, it can certainly take such a decision not to file an appeal.
No, you think
But
this has been taken?
Take such a decision on the basis
You think that this decision has been taken on merit or not?
of infusing confidence in foreign.
No, you think this decision has
I
been...
can't say. I have not gone into it so deeply.
Okay. Yes, Badri. Quickly, we are running out.
I guess I beg to differ with Prashant for the simple reason this is not an issue of capital gains. The capital gains, there is a separate regime for income tax. Applying the taxation for capital gains is completely different. Here the issue was at what price the shares was valued.
So are you trying to say that the Bombay High Court has upheld the valuation of the shares done
by the company?
You are saying that the Bombay High Court has upheld it?
Upheld the valuation of the shares done by the company.
Then in my view,
by the company, and which was disputed by the income tax department. There are different ways of valuing it.
Prashant, very quickly.
no, then in my view, that decision of the Bombay High Court is wrong and it should have been challenged in the Supreme Court.
Very
if
quickly,
that's
Mr.
the judgment of the Bombay High Court, which I don't think it is.
Okay. Mr. Dua, very quickly, last word.
Yes, I think...
No, because there seems to be
absolutely.
some confusion about this.
I think the issue certainly here was whether the company was liable to pay tax, the Indian Vodafone unit was liable to pay tax or not, and on the value of the shares.
On both issues.
Yes.
He's saying...
And the shares which they have issued to the Mauritius company, through which the investment had come to them, not their parent company in the UK, or whether the taxman's demand was right or not. The High Court has said that demand is wrong. And it is wrong on the grounds that, and the word used, I think, is transfer pricing. They have in the judgment used the word transfer pricing and said that this income is not taxable. But at the same time, the High Court has, according to the newspapers, used the report that if there was a tax liability, it was more capital in nature.
Okay, I think on that note, we need to completely run out of time. But obviously, there is still some confusion left in the minds of people about this. We'll wait and watch how it will all play out in the coming days. But according to some of my panelists, this is a good decision which has been taken, which will help investments. We'll wait and watch whether it will happen. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.